Thank you very much. Thank you very much, President, for the kind introductory words. As it has been famously said, will be brief. And I will focus my analysis on some of the elements of the opt-out procedure that have in part already been introduced and explored by my two great colleagues, Christophe and Martin. So I will skip or move fast through some of the slides. These are slides that were somehow, or concepts that were somehow already been addressed. Whereas I will focus maybe a bit more on some of the elements that I think that are interesting for our analysis. There is a brief reminder. This is maybe helpful to keep in mind, but it are concepts that we already analyzed. Article 3 identifies the opt-out to the right of reproduction. The AI Act creates a set of rules that include a variety of recipients of these rules, and it is important to keep in mind that some of the rules that we're looking at in relation to copyright focus on the category of so-called general purpose AI providers, so very specific category in this framework. And in relation to something that Martin has already been identified, there is, from the point of view of copyright law, very surprising provision, but from the point of view of the nature of the AI Act, not so surprising. We have to remember that the AI Act is a product safety type of legislation, and that in 180 articles and a similar number of recitals, copyright is really mentioned, well, really in only one article and a few, I think 3 or 4 recitals, and was only very recently invited to the party, in the sense that in the original Commission proposal there was no space for copyright. And most importantly, the way in which copyright is regulated in the AI Act is through a product safety approach. So whereas to think of the extraterritorial dimension of the training from a copyright point of view as a really surprising element in our field, it is rather common, on the other hand, to accept that if a product is not safe, cannot enter into the EU market. The interesting element here is that safety is included as in the definition as an element of this safety assessment is copyright compliance. So that's perhaps the original and an innovative element that deserves some further analysis. I think it's also interesting to look at the recital 105 because it has emerged to a certain degree this tension between text and data mining as expressed in the copyright directive, in the copyright digital single market, and generative AI as a subcategory of general purpose AI in the AI Act. And it is true, and I think that in terms of what is good law today, it is absolutely true. I agree with Martin that Article 3 and 4 apply to generative AI. The exact relationship, however, is not fully unpacked in the sense that I have heard more than once the argument that only Article 3 and 4 can be the basis for generative AI training. So, for example, not Article 5.1, temporary copies, despite the fact that the CDSM directive is very clear that Article 5.1, temporary copies, continue to apply to cases of TDM. So if we were to give a lot of meaning to this very not explicit reference to the recital, so again here is it's something that is not said and it is in a recital, then we could perhaps imagine, and I'm not sure exactly what is my assessment of that there are two types of text and data mining, the traditional one and the AI version of it. And in that case, certain exceptions such as 5.1, but also others, maybe even pastiche, I'll drop it there for Martin, are not available anymore. So this, I think, is an element to also keep in mind for our assessment. What is very clearly stated, I hear a echo sometimes, but okay. What is certainly clearly stated and is and it is in an article, so not in a recital, are the two obligations on GPI providers. One, to develop a policy that complies with EU copyright law, and one is to make available a sufficiently detailed summary. They're connected, but they have also interesting differences in the sense that the summary has to be made publicly available. For example, the informative disclosures of the first two paragraphs of Article 53 have a clear indication of the degree of publicness, if you want, that needs to be attached to them. So, for example, the technical information of letter A is only available to the AI office and other national authorities. The additional information of letter B has to be made available to deployer and AI system developers. Letter D, as we said, needs to be made publicly available. We don't know the degree of disclosure required by law of the summary. So it may very well be that, at least in terms of obligation, it remains an internal document that AI developers may decide to disclose or not publicly in relation to the investigatory powers of the AI office or during infringement proceedings. So this is my legal framework of reference for now. Here, as I was mentioning during the coffee break, I like to torture my students by asking them to represent graphically a research question. This is the graphical representation of what, for me, are the steps from a legal point of view. I think many of us have attempted this analysis, and I think it's an analysis that is very helpful for our own assessment and reflection. We don't need to go through all of it, but to me it is a very interesting representation of where we start, so the input data, when we arrive with the output data, all the steps that are necessary, relevant from a legal point of view. So there are many more steps from a technological assessment, but as lawyer we need to add this layer of analysis and synthesis and identify in the technological processes what are the elements that count from a legal point of view and which are the rights that are triggered by this legal / techno-regulatory dynamic. The truth is that the outputs, as I said, as I suggested, are of two types. Generative AI and TDM may represent two different kinds of outputs if we look at the definitions. But I do agree that as the intervention of the AI Act that links directly 4.3 to generative AI puts, in terms of positive law, if you want, them on the same level. Yet it doesn't mean that that they are exactly the same things. And I have a couple of pictures for you to suggest why there are situations where the values at stake may be different, and therefore the opt-out analysis may lead to different conclusions. Just to conclude briefly what I think it is the applicable legal framework, to give you an idea of the complexity of the resulting picture of the interaction between a product safety regulation that takes on the table copyright and copyright provisions, both new and old. We have 5.1, we have Article 3 and 4 of the CDSM directive, we have the surviving exception for research and education, which in the pre-CDSM was the basis for the national text and data mining exceptions, as Christophe has pointed out, I think, in your study for the Parliament already in 2019, if I remember the date correctly. We have the issue of what is the exact nature of the opt-out, because I think that in general, but also in terms of, for example, the example that Martin Senft-Leben was developing earlier on the levy system at the at the output level, a difference exists, or I believe should exist, depending on the nature of the opt-out, of the output. If the output is sufficiently similar to trigger a copyright infringement, or if it is, I could call it a machine-independent creation, to me the assessment of whether a permission, a levy, or any other form of legal barrier or need for avoiding this barrier deserve a different assessment. So for me, this is an important element, the proper classification of what the output is. And everything boils down to a very simple question, because my assessment focuses on the input side. I think that the input for me is what determines to a good degree the result of our assessment. And the question is there a copy in the model? Is there a copy? And the truth is that, and if I can go back to the words that Professor Di Cataldo used to open the session, perhaps we're not even in presence of concepts in look for a name, but we are in a phase where we need not only a new taxonomy, but a new, I could even say, epistemology. So whether this is a copy or not is both true and false, depending on where we look at it from the process. I would say if we were in a normal world where we are not yet familiar with the complexities of statistics, and I showed you this picture, and then I showed you this picture, and I asked you, is this a copyright infringement of this? Most people, most copyright scholars would say simply, well, no, because one is a set of numbers and the other one are two pictures. But whatever, if we could open a model, the only things that we would see are numbers like this that represent simply distribution of data points, a lot of vectors, multiplied by billions and billions and billions of times. And the issue of whether there is memorization in the model really only boils down to whether there is an unusual concentration of certain data points in a certain vector that is not justified by a proper learning performance of the algorithm, but may have to do with some problems. And these problems may be connected to overfitting, may be connected to unusual data distribution, so long tail data distribution, where the long tail represent a lot of the semantic value of that specific analysis, and to other unusual situations on the, let's say, statistical representation of this information. Is this copyright? Should it be copyright? And that, to me, is one of the big questions that we have to address, because we may insist that our old categories, what is a copy from a copyright point of view, apply to these situations, but I don't think that it makes any sense. And I agree very much with Christophe here. After spending too much time talking to computer scientists, I think that the only real conclusion is to conclude that whatever is the technical process doesn't matter, because it never really mattered. It has always been a process of attributing ex post a significance, a meaning to an act that we want to regulate, not because it is inherently a copy, but because we decide that that activity has to be regulated, and we call it copy. We could make but we will not. We could make a lot of historical examples, starting from the origin of copyright as a form of regulating the press, going to photography, to software, to many other examples. What I want to say is that it is an ex post assessment of what we want to regulate that determines whether this is a copy or not. There is no real, pure theory of copy. It does not exist. And this will then help us to determine the answer to whether this is a copy. So when I ask ChatGPT to make an exact copy of Mickey Mouse, and it warns me that it would be a copyright infringement, but then it explains to me how to make it. And draw a mouse with yellow, red pants, yellow shoes, the big ears, etc., etc. That's not a copyright infringement, but how much information you need to give me in order to trigger copyright infringement? Because this is the same question that we would ask in the relationship between this and this. How much information triggers that? So the question is, first of all, to determine in a statistically dominated technological world what we want to regulate and therefore what we want it to be a copy. The other way around, to me, doesn't lead to a satisfactory answer. I have a couple of more examples, like asking to write in the style of someone, and the machine is certainly able. And even here, the question of what is a copy? Is copying the style of an author? Is that a copy of something that copyright protects? Is there a difference between a genre, style, a style of an author, a personal style? How much information do we need to capture what copyright, or perhaps other rights close to copyright or close to personality rights, we would say, need to be protected? But once again, until when we don't have a clear view of what we want to regulate in terms of innovation policy, industrial policy, and cultural policy, all answers are, I would say, valid and not valid at the same point. We are almost in a quantist kind of paradox. If we don't know what we want to regulate, sure, is that a copy? Yeah, why not? I mean, it certainly has certain elements of copy. I could argue that. Is that not a copy? No, it is not. I could argue that too. But until when we don't have a clear view of what is that we want to regulate, then that will be counterproductive. Once we have clarified this, and I'm not saying that I am any closer to the clarification, but I think now I am a bit more clear on what is my problem when I approach this angle. So to define what is that we want to regulate, then acquires much more sense to look at the opt-out from what and for which purposes. We already saw again, it's a very colorful and visual representation of the articles that we saw at the very beginning. But here is where we place the interaction between the AI Act and the CDSM directive in the machine learning process of GPIs. In the past, again, this is not an entirely new problem. In the past, we had the issue of Google as a search engine scraping websites, and the old solution was the robot.txt. So a piece of HTML code that would tell the bots that automatically scrape the web whether they can or cannot proceed to analyze that website. And the robot.txt is not as basic as is often portrayed. We could, the website developer could indicate which parts of the website can and cannot be searched by which bot, so you could discriminate, for example, between Google and Microsoft, and even within the same company, also different bots. So the search engine, yes, but the news feed, no. So this is a degree of granularity that often is forgotten. And imagine to adopt a robot.txt structure to the new TDM/AI environment, we could imagine something similar where we allow Google to index our website for search engine processes. So we want to remain visible when someone looks for some information in Google as a search engine, but we don't want to allow his scraper to analyze our website in order to acquire data to develop machine learning, to train their model. With the added value that now this compliance is mandatory, we don't have to look for some sort of theory or doctrine of implied consent often to justify the enforceability or contract to justify the enforceability of that provision. Now Article 4.3 clearly makes it mandatory. There are a number of problems with that, and Martin mentioned some, so I will go a bit faster and maybe focus on some of the solutions, but certainly the subject matter is a problem. We need to identify a technology that is able to distinguish, for example, between Article 3 TDM and Article 4 TDM. And that is very difficult to do it unless you declare that. So it needs to be a sort of mutual compliance, the fact that, I declare that this technology is scraping only for Article 3, but not for Article 4, meaning I am a research institution acting for research purposes. Okay, then I can go through the whatever gate or lock is been put there. I'm not a research institution or cultural heritage institution acting for research purposes, then I have to stop. Obviously, if we put this in the form of a TXT file, it's about mutual compliance and eventual litigation. But if this is translated to protocols that implement this command at the code level, so for example, digital locks or rights management systems, this discrimination is very difficult, and we know from practice that if there is an error, it's an error of over-compliance. So a lot of requests that are based on Article 3 will probably be blocked in the same way in which the old e-commerce directive and now the DSA tend to overblock parodies and other lawful uses on YouTube. There's an issue of univocity, so how many times there are similar files online and how we can address the issue of contradictory statements. Of transactive cost, if we have many platforms and many items, how many times does a right holder has to opt out? Because this is a cost that could really hamper the ability of a right holder to enjoy their Article 4.3 opt-out. Temporality, since when? How can we establish the date of the opt-out and the date of the training? Because that, of course, determines whether that act has been taken place before or after the reservation of the use. And the spatiality, I wanted to continue the taxonomy, but it would be the extraterritorial effect that Martin has made reference to, which are surprising, are a Brussels effect, are a way to preempt other jurisdictions or to influence them, because if your standard, even in terms of regulatory theory, becomes this standard, there is an advantage in that. It's true also the opposite. All of this, without that provision, has no sense. Because already most AI developers, we heard that from Joseph and the other speakers earlier, are already tendentially not based in the EU. If we introduce a legal framework that makes it more expensive, the few that are there have a very strong incentive to not be there anymore. So if, and I wrote that with a couple of colleagues, the problem of recognizing property rights in data is also this one, that once you allocate a property right, often you create a formal value on that. And when you create that formal value, then you attribute a cost, because the person or the entity who has that value wants to maximize that. And therefore, it becomes a lot more expensive in terms of not only monetary, but also in terms of transactive costs to train in the EU. And therefore, either you have an extraterritorial effect, or the whole system will simply push away innovation. And there is not a lot, but there is some empirical literature that has been done in relation to text and data mining. I will skip, of course, on remuneration, because we have the experts here. And I conclude only on the issue of the different protocols that have been so far developed. There are more. These are the ones that I know a little bit better. I will not discuss them in detail, also because I don't have the technical knowledge to be able to explain to you, for example, all the bullet points there. But I think what is interesting here to see is that once again, technology tends to surpass us in terms of legal analysis. A lot of the problems that I have identified in terms of, for example, univocity, in terms of temporality, so how we can identify the exact moment of the training and the exact moment of the opt-out, can very easily be implemented at the technical level. It is cheap, the technology that is there, it can be done easily. Footnote, GPI providers working currently on the codes of practices don't want to do that. They are absolutely clear that to them this is an excessive burden. that would violate their trade secrets and business confidentiality because they give away relevant information that may put them at disadvantage with competitors, etc., etc. So they don't want to do that. That's clear. They have submitted plenty of evidence in this sense. But it can be done if we want it. So, and maybe just to conclude, I think that where we are all right now, so where is all this being discussed? So my analysis is almost concluded, but I want to call your attention to the venue of where all this is being discussed right now, and it is at the level of the codes of practice that the AI office is developing. There are different working groups. They are very successful. The original expectation was around 40, 50 people. Each working group has around 500 people, participants. And a lot of these decisions will be formulated there in a sort of bottom-up multi-stakeholder effort that should lead to the presentation of the code of practice by May and the eventual adoption by the AI office of these codes of practice as a way to formalize a lot of these discussions and decisions. And I think this is a very interesting answer or proposal to answer the question of that I asked before. So what do we want to regulate? I think that for the first time, or maybe not the first time, but certainly in a very interesting model, we have an answer coming by the legislator saying, well, you know, then you academics, GPI providers and right holders try to sit down and try to come up with something that it is functioning, that somehow agrees with all of you, because the function of these codes of practices will be where the whole discussion is settled. The degree of granularity of that summary will determine whether it is work by work, which will not be, but how closer we get to that and how much we can empower individual right holders to obtain remuneration for the use of the single work, or whether this will not happen. So that point, that venue, is the venue of where the actual regulation of this situation is done. And I think that an interesting alternative to the, and then I promise I am done, an interesting alternative to the model that both Christophe and Martin has proposed, which is based on remuneration, even though in two very different models, is to try to apply this concept, this policy vision of the European Union of common European data spaces, or better to develop a data union, both at the regulatory but also at the infrastructural and economic level. It is certainly not there yet, but there is a lot of effort to make it happen. And this could represent the way in which the EU could maintain its own AI self-determination or AI sovereignty. So a space where data will never reach the quantity that it's possible to find in the US or in China, the regulatory environment, the availability of data, the legacy situation, the hedge funds. But we could imagine a smaller pool of data, which is, however, characterized by much higher quality, because the trust, at least in the intention of the regulator, that we will infuse in this system will not only make public held data mandatory reusable, but will also incentivize privately held data, so the big industries that own data, to share them for mutual benefit. It sounds very idealistic, but the other alternatives do not put the EU in the front stage. We'll put them in the back of our picture. So I really think if we have space for further research, we should develop this further. Thank you very much.
Many thanks to Professor Margoni for this very interesting full picture